Hello, good morning to you, and many thanks for joining us. You're watching Galaxy today, coming to you from Galaxy Television. My name is Justin Akadonia.
And of course, he's not alone. He's with Uchi Onnoghen. It's good to have you this morning, the 26th of March 2019. And of course, today we're looking at Onnoghen's criminal charges, and I'm sure there are updates I would like to share with you. Justin, okay, let's go back to how it all started, when this Onnoghen's case started. But we all knew how the other legal practitioners reacted to this, and your own opinion. Would you say that the charges that were posed at him are actually what it is, or could this actually be a political stunt?
Well, as at Friday, the federal government closed its case against and embattled Chief Justice of Nigeria, Justice Walter Onnoghen, for the Code of Conduct Tribunal, where the prosecution failed to prove most of the allegation carried by the media against him. Onnoghen has opted to go for a no-case submission. Okay, he's currently facing a 6-count charge. The federal government preferred against him before the CCT. He had joined the trial, raised the alarm that his assets declaration form before the Code of Conduct Bureau was tampered with. The embattled CJN, who was suspended from office by President Muhammad Buhari on January 25, was removed shortly after he fixed date to inaugurate judges that will hear petitions arising from the 2019 general elections. The federal government had last week Thursday closed its case against the suspended CJN after it produced only 3 witnesses that testified before the tribunal. Let's just take a snippet from that case on Thursday, and we'll now join our guest in Lagos, Abuja, and of course in Ibadan to look at the issues this morning. Do join us again.
It has brought us to the time when we closed the case for the prosecution. We have called our witnesses, we have tendered the exhibits. That is the duty of the prosecution, to put before the tribunal what was investigated, the fact that was discovered. Whatever the tribunal does with those facts are matters within its powers, but we have finished our duty. And I thank you very much for reporting everything, yes.
Why would I tell you whether I'm satisfied or not? The witnesses have given evidence, I've examined them, and I'm now to write my address. The point is really is that I don't want any journalist to go to jail. I felt so scared when the lawyer kept on repeating it. He must have had my evidence.
God, it has brought us to the time when we closed the case for the prosecution. We have called our witnesses, we have tendered the exhibits. That is the duty of the prosecution, to put before the tribunal what was investigated, the fact that was discovered. Whatever the tribunal does with those facts are matters within its powers, but we have finished our duty. And I thank you very much for reporting everything, yes.
Why would I tell you whether I'm satisfied or not? The witnesses have given evidence, I've examined them, and I'm now to write my address. The point is really is that I don't want any journalist to go to jail. I felt so scared when the lawyer kept on repeating it. He must have had my evidence.
All right, welcome back. It's still Galaxy today, and we're looking at the Onnoghen to face a criminal charge. And we want you to be part of this discussion. Feel free to interact with us on social media using the hashtag Galaxy Today. You can also send SMS if you have questions or comments, for our guest. All right, still talking about the case on Thursday. The federal government had last week Thursday closed its case against the suspended CJN after it produced just 3 witnesses. The first prosecution witness, PW1, Mr. James Akpala, who is a senior investigative officer at the CCB, had in his testimony told the tribunal that the charge against Onnoghen was filed because his team concluded investigation on the allegation that he forcefully declared his assets. Similarly, the second one, Mr. Awal Yakasai, who is a retired director at the CCB, told the Mr. Omar-led 3-man panel that contrary to what was alleged in the media, he said the suspended CJN owned only 5 houses. He said it was not true that the CCB investigators linked the ownership of 55 houses to the defendant. The witness made the disclosure after he was shown copies of Justice Onnoghen's asset declaration forms, with the federal government tendered in evidence before the CCT. The embattled CJN was said to have submitted the forms marked as Exhibit 2 and 3 to the CCB in 2014 and 2016. Answering questions under cross-examination, the second witness admitted that the CCB was yet to verify Justice Onnoghen's assets with a view to finding out if he made false declarations before a charge was filed against him. More so, the PW3, the third witness, Mr. Ifeoma Okagwe, a staff of the Standard Chartered Bank in Abuja, told the tribunal that it was not true that the defendant possessed either $1 million or £1 million in any of the 5 bank accounts that necessitated the charge. Okagwe, who told the tribunal that she started managing Onnoghen's bank account since 2015, gave a lowdown of both the opening and closing balance of all the accounts from January 2018 to January 2019. In a moment, we'll be joined by a legal practitioner, Barrister Abumere Osara, to discuss these issues with us after this quick break. Do join us again.
It has brought us to the time when we closed the case for the prosecution. We have called our witnesses, we have tendered the exhibits. That is the duty of the prosecution, to put before the tribunal what was investigated, the fact that was discovered. Whatever the tribunal does with those facts are matters within its powers, but we have finished our duty. And I thank you very much for reporting everything, yes.
Why would I tell you whether I'm satisfied or not? The witnesses have given evidence, I've examined them, and I'm now to write my address. The point is really is that I don't want any journalist to go to jail. I felt so scared when the lawyer kept on repeating it. He must have had my evidence.
All right, welcome back. Joining us this morning to look at all of the issues is a legal practitioner, Abumere Osara. Many thanks for joining us on Galaxy today.
Good morning, it's good to have you.
Oh, thank you for having me.
Okay, we're looking at Onnoghen's criminal charges. he's dismissed from the court. We know that a couple of things have been dropped, but Looking at the whole case now and where it has brought us to with these charges, as a legal practitioner, what's your reaction to all this?
Having regard and taking into account the clear provisions of the Constitution, and then the established, settled legal principle on the point, settled cases, decision of the Supreme Court, particularly the case of Elilu Habib. That's the case involving the SY Chief Judge of Kwara State, where the then governor of Kwara State, Bukola Saraki, purported to remove the Chief Judge of Kwara State, acting on an address of the House of Assembly of Kwara State. And then the Supreme Court went to town to interpret the provisions of Section 292 of the Constitution with regard to the removal, the process and procedure for the removal of the Chief Judge. And then interestingly, now what happens to the heads of state courts and also the heads of federal court is the same provision of the Constitution that covers them. You find that's why you find that Section 2921 deals with heads of federal courts, while Section 2922 deals with position with respect to state courts. So now that decision, Elilu Habib, settled the principle that the first port of call when you want to discipline or remove a judicial officer, and indeed the head of the court, that the first port of call is the NJC. Now, the later cases, or the later case of Ngajiwa, restated that principle. So we thought that the government will be guided by the provisions of the Constitution as ably interpreted by the Supreme Court. So some of us were quite surprised that the federal government, through the Code of Conduct Bureau, could, without fulfilling the condition precedent, arraign the Chief Justice of Nigeria before the Code of Conduct Tribunal, having regard to the fact that just last year alone, Justice Unguta, who incidentally is a Justice of the Supreme Court, had a matter before the Code of Conduct Tribunal, and on the basis of the decision of Ngajiwa, which rely more or less on the principle laid down by the Supreme Court in Elilu Habib's case, declined jurisdiction to say, look, the first thing you do is you go to NJC. And I would have thought that also too, having regard to the fact that only recently, belatedly, the EFCC is reported to have written a petition to the NJC with regard to the alleged conduct of the CJN, that the government would have withdrawn the charges before the CCT. But surprisingly, they went ahead, called about 3 witnesses, and then having regard to the way the case seemed to have gone, they closed their case abruptly. They listed 6 witnesses, they only caught 3. And so far from what you can see, the ingredients of the offenses for which the CJN is charged seem not to have been established. Yes.
Right now, there are a new angle to the top government officials, or top government official rather, is claiming that the embattled CJN may face 2 fresh trials. From what we hear, he's claiming that Onnoghen is the owner of some domiciliary accounts primarily funded through US dollar cash deposits made by himself. He's further alleged that there were unexplained payments into Onnoghen's account by lawyers who at the same time were appearing before him for adjudication.
Well, the whole thing is beginning to look like witch hunt and persecution. One is beginning to wonder, to ask the question, what does the federal government really want to achieve? Why are they after Onnoghen? I'm not aware that it's not as if the federal government had taken a decision. to carry out a general investigation of judges throughout the country and also members of the executive. Why Onnoghen? And then it's interesting, it's curious that this latest angle came out after the seemingly lackluster performance at the CCT, when it's obvious, it's clear to all and sundry that the case would appear to have fallen like a pack of cards. Because rather than proving the gate of the CGN with respect to the charges before the CCT, the three witnesses called seem to have exonerated the CCT. In fact, it's a complete embarrassment to the federal government and to Nigerians. That it's as if our officials, they don't know what they are doing. How can you frame a charge against a Nigerian, not talk of somebody holding the exalted position of the CJN, without first of all verifying to ascertain whether the allegations in the petitions or the statement containing declarations are true or false? And then you ask yourself, on what basis did they now come to the conclusion that the CGN, has made false declaration? First of all, first thing you do is you verify.
Okay, do your investigation.
You do your investigation. You verify. After verification, in fact, the onus still rests on you, by the way the CCP works, to confront the public officer to say, look, these are the declarations you have made. We've made our own investigations. These are the things we have found out. If you insist, then you can now act under the power given to the bureau under Section 3 of the CCs of the Act to refer the matter to the tribunal.
Okay, let's get other perspectives onto this matter, and we'll come back to you, Barrister Osara. Let's go to Ibadan. We have another legal practitioner joining us, Chief Sulaiman Ajiwale. Many thanks for joining us. I want to get your own perspective concerning all of that after what transpired at the CCT on Thursday. Well, this new allegations and coming out, what does this really tell you? A school of thought will believe that this is in deference to the fact that if there are any claims of such as being put out, it should go through the NJC first before, maybe an arraignment or so. What are your thoughts specifically considering all of that?
The producer, I must say I want to adopt completely what my learned colleague said in respect to this matter. It is indeed an embarrassment to us as a country, especially a country where we prefer that we are practicing democracy. Democracy cannot thrive if there's no rule of law. And what is rule of law? Ordinarily, the rule of law means where might does not reign, where law, both substantial and procedural, reigns in the country. That is what the rule of law means. Now, from what we have from the tribunal, it is clear that non-allegations have been proven against the suspended Chief Justice of Nigeria. As Judge said, all the three witnesses exonerated him. In fact, it's embarrassing that his declaration was not verified. It's that single one that we have not verified the declaration. If you say you have not verified the declaration, how then will you come to term that the man has not declared his true asset when you have not verified it? I must say, but law is no respect of anybody. The English people will say, the head of sinners dies, affect only the small fishes in the society. But what we are now seeing in this country is beyond that. What we are now seeing is a situation where anybody that is not in agreement or disagreeable to some part of B can be verified at any time. And to be honest with you, many of us are very sad about this development. So far, 3 witnesses were caught, and abruptly, the prosecutor closed his case. That they don't have any other witnesses to call again, because they know that they are already embarrassed by the 3 witnesses that have given evidence so far. So calling the remaining 3 witnesses would have been more of embarrassment to them. So, but what they are now saying is that EFCC is also investigating the CJN. Well, the EFCC has the power under the law to investigate anybody, even a sitting governor or a sitting president. What they cannot do is to prosecute them into the immunity clause provided for in the 1999 Constitution. But if one is able to add 1 + 1, one will realize that all this investigation is only to steer up the judiciary. The democracy has a tripod: the executive, the legislature, and the judiciary. In a situation where one of the hands of government is being twist with what we are seeing in this country, I pray that Nigeria will not become a banana state. That is my contribution to it. What the?
All right, a top feature, like I have said before, is a legend that the CJN is the owner of some domiciliary accounts primarily funded through US dollar. He said what was more disturbing is the pattern of the deposits, which according to the EFCC were made in a manner inconsistent with the financial transparency and the code of conduct for public officials. He said these include instances of repeated cash deposits of $10,000 each, totaling close to $2 million. Said these serious allegations would ordinarily have gone to the High Court for prosecution, but for a case precedent which stipulates that such allegations against a judicial officer should be first presented to the National Judicial Council, more or less in an internal disciplinary panel for erring judicial officers before being prosecuted in a criminal court. My questions right now would be that if the EFCC and the federal government, seemingly had all of this, this case to put forth, in their own issues, how come they were just focused mainly on the asset declaration, issue with the CJN and not really, prosecute him on criminal charges before now?
That is the main problem. You see, when you are working to an answer, you will make a lot of mistakes. And I'm telling you, when arrogant people in power, if they don't make mistake of law, they will make mistake of procedure. To me, there's a set goal. This man, the Chief Justice of Nigeria, has to be dealt with. And that is why the procedure has been so nauseating that you continue to believe that are we in a country, are we in Nigeria, are we practicing democracy? Let us be sincere with ourselves. Now, the allegation of that the EFCC is now investigating, as you rightly said, it must first of all be referred to the National Judicial Commission. But because some people in power, the point that big, want to make sure that even before the general election of 2018, the judiciary should be well cowed. I believe, I'm saying this with all sincerity, I'm not a member of any political party for that matter. I'm not a politician. I'm talking as purely a Nigerian and as a legal practitioner. The offense in criminal jurisprudence is on the person that alleges that will prove the guilt of the defendant. So far, you send this man to Code of Conduct Tribunal, you whitewash your own evidence before the Code of Conduct Tribunal, and you're not fishing for evidence. It's like fishing for evidence to prosecute him by the FCC. But we are living in Nigeria, let us see where all this will get us. But to me, it's a sad day for democracy. And it's a sad day for the judiciary. This trend must stop. If we really want to have a country that we're proud of. That is my take on this. If we really want to have
from Ibadan in Oyo State. All right, we still have Barrister Abumero Osara, a legal practitioner with us here in our legal studio. We'll still go to Abuja in a bit to get more reactions. You've heard what your legal practitioner has said concerning the new angles and new perspective. You have more to add concerning what he had said.
Yeah, I adopt fully the submission of my learned friend from Ibadan. It's quite clear that what the government is doing, you know, they are fishing for evidence. As far as they are concerned, apparently they don't want him anymore. I don't know. We don't know what they have against him in person. Maybe they have not come out to tell us. Maybe it's more than what they are bandying about. It's more than these issues of account or declaration of assets.
But are you saying that it's quite political? Probably there is something. It could be. It has nothing to do with his position as a CJN. It's his person now.
Well, I've heard it said, you know, within some legal circle, that perhaps Mr. President is not comfortable with him.
Okay.
That Mr. President is only comfortable working with certain people from certain parts of the country, his own part of the country, and the same religion. You know, so I shudder to even hear or imagine that President of Nigeria, you know, could operate in that manner. But when you look at the facts on the ground, you know, from the way he has made his appointments in the last 3.5 years and all that, and then one is tended, you know, to say perhaps there is some truth in what some persons are saying, that he wants his own person from his own part of the country and from his same religion. And you have to be very careful. You know, Nigeria is a diverse, plural society, multi-religious. And the CGN is from Cross River State, you know, up north Cross River, from a minority group. So the president should be broad-minded. He has to embark on his by his actions and policies to carry everybody along, so as not to make people to begin to imagine that he's exhibiting or showing sectional tendencies. But I don't want to believe.
Yeah, because if that is the notion, how come we have a vice president that is not from his own part of the country?
Well, like I said, that is what some people feel. Okay. And you pose the question that yeah, why is this happening? So we're trying to find out what is going on. If we are to go strictly by the nature of the charges and the allegations against the CGN, we can say, right from the point of view of law and from the point of view of facts, that they don't add up.
Okay.
But similarly, you notice that it was after the federal government closed their case that over the weekend that they came up with this story, media trial. They want to convict him before the public.
Okay, let's get a perspective from Abuja, then we'll talk some more. We have joining us from the Federal Capital Territory, Jide Ojo. Many thanks. I'm sure you've been following the conversation. Looking at what has happened just on Thursday last week with the prosecution closing its case on the embattled Chief Justice of Nigeria, and over the weekend we're hearing that more criminal charges would be brought, preferred against him. In your opinion, do you really see this as tenable, judging by the fact that on Thursday the prosecution barely could prove its case against the CJN?
Well, it's so unfortunate that what we are having with the #1 legal officer of this country is being done not in the courtroom, but more of being done in the court of public opinion. I was all for anti-corruption fight. There is no problem if the man has soiled his hand that he should face the music, but procedurally, that's where I have issues. A lot of media trial went to Onnoghen's case, the suspension, the prosecution, which some people have termed persecution, and now just about the time that you couldn't prove your case of false asset declaration, you are now coming in with fresh allegations, fresh criminal allegations. Well, we wait to see how all of this will pan out. They said they have petitioned the EFCC has petitioned the NJC over issue of bribery, issue of money laundering, and receiving remittances from senior advocates of Nigeria. If the presidency can prove its case, all well and good. I think it's geared towards having a better judiciary. What I'm just against is short-circuiting due process and conducting this in the media rather than taking your evidences and exhibits to the courtroom to get conviction. So it's a double-edged thing. In one breath, we want to see anti-corruption fight being tightened and scapegoats being made. But on the other hand, while you want that to be done, you also don't want a short-circuiting of due process, of rule of law, of equity, right, and justice. Because when you sacrifice all of this at the altar of making sure that somebody goes to jail, then you are not sending the right signal. Some conspiracy theorists have said, why is it that first they went for the head of the National Assembly, the same code of conduct could not prove his case up to Supreme Court, the man was discharged and acquitted. You are descending on the judicial arm, trying to also, pin allegations against him. And from what we were told of what happened in the code of conduct, the 55 houses they said the man had could not be found. They said he has 5, out of which one of the houses were given to him by the federal government itself. And you can't say a judicial officer who has been more than 30 years and since 2015 at the top echelon of could not build up to those houses. Then you said there was huge deposit in his account. they now discovered that instead of millions of dollars that were alleged to have been found, they could only see few, maybe about 50,000 or thereabouts. The bottom line is that you don't want. I don't support. Calling a dog a bad name in order to hang it. Yes, it's good if anybody has infracted on the law, if anybody has acted on the wrong side of the law, for that person to face the law. But again, you shouldn't just for the sake of conviction just throw caution to the wind, throw due process to the wind, throw rule of law to the wind in order to achieve your predetermined intention.
See this as maybe a perceived, will I say, waste of legal process and legal proceedings, and judging by the fact that, as you have, candidly pointed out with the case of the Senate President Bukola Saraki and now that of the judiciary, is it a case of where the executive has not actually done its own homework before bringing all of this stuff to the fore and just going around, some people have claimed with frivolous allegations and frivolous charges? Do you think it's just a complete waste of legal process and proceedings?
You can say that, but I think due process that I talked about that should have been followed is that there should have been thorough investigation before arraignment. We were told last week that EFCC went to his farm along Nasarawa Road to start looking for evidences. These are things that should have been done to ensure that they have ironclad evidences against him before arraigning him. Are we saying that the prosecution do not know how many property he owned? And we are even being told that the so-called asset declaration form that upon which his current travails at the CCT is being done, that asset declaration form has not even been investigated since he filed it. If that is true, then somebody is working to the answer, and that's what I find worrisome. Because if we are not very careful and we demonize our judiciary, which should be the last hope of the common man, by the time we humiliate and we sacrifice the best of our judicial officers, it then means that people will stop having faith and confidence in the judiciary, and the alternative to that will be self-help. So, straight to your question, it will seem so that the presidency may not actually have a convincing evidences against the suspended Chief Justice of Nigeria. Rather, they didn't want him to play any active role in the election petition tribunals that were inaugurated recently. And possibly, like I've said on other media platforms, they are trying to give him Justice Issa Yosalemi's treatment of just suspending him and making sure that they waste the time of the court in order to ensure that he doesn't even have the fighting chance of coming back to his office. Because this will seem like how this old charade is turning. It will seem like due process and has not been followed. Although I must also hasten to say that I wish we have had from the NJC investigation team on the petitions that have been submitted against the CJN, because having asked him to respond to some of the petitions in writing, this has been like 2 months now. One will have expected that NJC will have come out with their report of investigation to say whether there were actually prima facie cases that have been found against the suspended CJN, after which it may then be handed over to anti-corruption agencies for proper trial. But I think in my own estimation, the NJC is foot dragging on this whole thing since they stepped into the RA about 2 months ago. One thing that they should have fast-tracked the entire processes of doing their own prior investigation, having received the response of the suspended CJN, is Lordship Walter Onnoghen in writing. I believe that by now they should have come out with their own interim report to know whether, from their own findings, the man was actually culpable of some of the allegations against him. After which, then the anti-corruption agencies, be it ICPC, EFCC, or even the Code of Conduct Tribunal, can take over from there. But not having heard from NJC is actually also fueling speculations as to whether there is no complicity somewhere along the line. But a man is presumed innocent in criminal allegations until he's proven guilty. So the onus is on those who allege to prove their case beyond reasonable doubt, because this is a criminal allegation. So in the eye of the law, His Lordship, Honorable Justice Walter Onnoghen, is still presumed innocent of all the allegations, and until he's proven guilty, that's where we can condemn him for wrongdoings. So I hope at the end of the day, justice will not only be done, but will be seen to have been done.
All right, thank you so much. We've been speaking with development consultant Jide Ojo, who joined us live from the Federal Capital Territory in Abuja.
Okay. Sid, you heard everything he said.
Yes.
I'd like you to first react on them, as well as what's the role of the NJC in all this. But let's first react to what he said.
Yes. Thank you very much, Mr. Jide Ojo. I would like to appreciate him for his contribution and discourse to ensuring that we have a better Nigeria. Now, I don't think the NJC has delayed in any way.
Okay.
Now, it seems as if most Nigerians do not appreciate or understand how the NJC works. Now, the NJC, the petitions were already received sometime early February. You know, and then they first of all, they set up a committee to look at. And then they established that, oh, it was worth investigating.
Okay.
They now set up a proper committee now to investigate. They work like the court. They give all the parties an opportunity to present their case, even file pleadings or file written addresses, and then be presented by lawyers. And you can cross-examine. So you must appear before them to prove your case. That matter is going on. EFCC has made a report, and I understand from what we read in the news media that the petition of the EFCC is almost like a rehash of the petition submitted by the infamous gentleman and all that. So let us give the NJC time to do their work and make their recommendation. And then one other thing Nigerians have to bear in mind is the fact that when it comes to the question of dealing with the CGN, the Constitution has prescribed the mode and manner, the procedure to be followed towards its removal. Now, once the NJC finish their work, they have to make a recommendation. If the recommendation is that the NJC has a question to answer or should be removed, they will forward the recommendation to the president. The president cannot act on it. He has to forward that recommendation to the Senate of the National Assembly, who must meet, pass a resolution of 2/3. We have about 107 senators, which means 74 senators must agree before the CGN of Nigeria can be removed. So it's not just a question of NGC finish their work and then you commence criminal proceedings. EFCC should not prosecute their petition in the news media. They should go before the NJC. Now that they have agreed, they admitted after a long while that the first port of call was the NJC. They are before the NJC. Let them make their presentation before the NJC. And they should not be looking, what they should have done, just like my colleague in Abuja and Ibadan said, was that they should have carried out discreet investigation, thorough investigation. Imagine only last week they went to his farm in Nasarawa looking for evidence. This has become a recurring decima. And the EFCC has been frustrating the fight of government against corruption with their shoddy investigation and shoddy manner of handling things. Something needs to be done to the EFCC, to rejig the EFCC, to make them more effective towards tackling corruption.
What would you rather recommend that should be done to them, the EFCC that is?
Maybe you change the headship. Send them for more training. And then engage persons who are committed, patriots, incorruptible, and then send them for proper training in the act of investigation, information gathering, and processing.
Okay.
Not behaving like the normal, you arrest, and then you start looking for evidence. And then all the time, you're not able to prove. And then at the end of the day, you begin to blame the judiciary. You don't convict, you don't arraign people before the media, convict them before the media. It's not for show. This is serious business because the lives of Nigerians are concerned.
Okay, please, I'd like to butt in here, still on the NJC thing. Do you not think that NJC took a while to have actually played a bit of their part? Because I did remember when this was discussed in late January, they did say that the federal government has no right, or according to the constitution, the CJN cannot just be suspended or be sacked by the federal government. Okay, so seeing that he's answerable to the NJC, do you not think that the NJC has rather taken too long to play whatever role they want to play now?
You see, that's the narrative being put out by apologists of the government, where they were trying to explain away the constitutional action taken by Mr. President in constitutionally suspending the CJN. Now, the NJC as a body cannot on its own go into the fray. To activate the jurisdiction of the NJC, there must be a petition.
Okay.
That ought to be investigated. The NJC, like I said, acts like the court. Now, there is no standing body. NJC exists in name. The members are known. They have their normal functions. It is when, and then they have periods of time when they meet from time to time, or as the need arises. It's not as if you have a body already sitting down there to consider and they take action without being invited, just like the court system. If you don't file an action in court, the court will not come in to your aid. As soon as the NJC received a petition, and they constituted a team to investigate.
Okay.
And they follow the procedure that they have always adopted over the years. And there are procedures and rules and regulations and guidelines with respect to how meetings are convened. Because I remember at that time when the issue first came to national limelight, there was the allegation, the government apologists, they were up in arms saying, oh, the CJN cannot constitute, oh, he doesn't want to constitute because he's involved and all that. Meanwhile, there are rules within the NJC rules which has taken care of that sort of situation. And that rule was put into effect, by which some members came together in line with the guidelines, and they convened a meeting. And usually, at such meetings, the party involved, who is subject to the investigation, if it's a member of the NJC, will recuse himself, and that's what has happened. Government should be patient, allow the NJC to do their work, and make their recommendation. But I dare say that from what we see is, like I said, maybe the government, the ruling party, the regime, they don't want him. Or maybe they want to send a message to the judiciary. They want to put the judiciary on the stools to say, look, we want you to decide cases the way that we want.
Okay, but looking at all of this now, as we wrap up now on this particular discourse, do you see the embattled CJN being reinstated, judging by what transpired with the close of the prosecution on Thursday last week?
Now, if the counsel to the CGN has indicated that it's filing a no-case submission. Now, if the no-case submission is upheld and the case is dismissed, it will mean the order by which the president purported to rely upon to suspend him will also be vacated.
Okay.
So there'll be no, legally speaking, there'll be no legal impediment to the CGN resuming office. But it seems the fifth columnist in this regime do not want him to come back. So that's where they are laying foundation. They have their target. Their target audience is not the intelligent, it's not the journalists, intelligent people. It's for the masses, the common man. The common man who has been oppressed over the years, who sees a government fund being frittered away or mismanaged and embezzled by those in government, who have been praying, waiting silently to see those persons being brought to book. So that's their target. They say the CGN was alleged to have millions of dollars in his account. Now, the account was presented at the CCB. We did not see millions of dollars. Okay. They said he had over 55 houses. And now, the document was presented in court. What we saw was just 5 houses. And out of which one of them was said to have been given to him by the federal government. So it's sad that the way things are going. Nigeria is supposed to be a constitutional democracy. We are not a banana republic. We are supposed to be guided by the rule of law, due process, and there is supposed to be separation of powers, which means that the three arms of government, the legislature, the executive, and the judiciary, they are independent and separate. They're supposed to work together. But it will appear as if from the treatment that this regime meted out consistently to the National Assembly, and what the treatment they have meted out to the judiciary. You recall that they went to attack overnight the homes of judges. And then when some of the judges, they couldn't find anything in the homes of some of the judges. For the few that were arraigned, they couldn't prove any of the allegations. It's like they have made up their mind to say, let's convict him. Now let's look for materials to support what we want to do. They are working towards the answer. Democracy should not run that way. Well, and I want to urge all Nigerians to stand up and say to government that you are on the wrong path. Toe the path of democracy. Toe the path of constitutionality and rule of law. Do what is right, not only for today, but for tomorrow. The president should leave a legacy. He came in with a high rating of being a man of integrity. Nigeria has been kind to him. He was in the military. He was a military governor. And then he was NMP, Minister of Petroleum. And then he was the head of state. And then twice now elected as president. The least we expect of him is to give us good governance, and that's fairness, hopefully, equity, and justice, not partiality that he has displayed in all of his actions all over the country.
Thank you so much.
Thank you so much, sir.
Our guest in Lagos has been Barrister Abumero Osera. We've been looking at the embattled Chief Justice of Nigeria, Justice Walter Onnoghen, to face criminal charges, going by what we heard in the news over the weekend. Many thanks once again.
Well, thank you for having me.
And of course, in Ibadan, or your state, we have Chief Sulaiman Ojewale, a legal practitioner, and also Jide Ojo, a development consultant in Abuja. I want to say big thanks for gracing this program. And for you who sat back to enjoy it, we say thank you. We're back tomorrow with health at 10 a.m. I'm Uche Onyekuji. Bye for now.
And I'm Justin Academia. Many thanks for being a part of the show. See you again tomorrow when we'll be looking at health. Bye for now.